Call the second case on this morning's docket. That is case number 106703, State of Kansas v. Christian Reese. If you give us a moment for Justice Moritz to take her seat. Counsel may proceed.
Thank you. Good morning. Jay Norton on behalf of the appellant Christian Reese, and I would request 3 minutes of rebuttal time, please.
3 minutes is granted.
Thank you. The Court of Appeals held that because the look-back provision of the DUI statute affected sentencing, it was substantive and not procedural, and therefore would operate prospectively only. My argument is that the amendment to that look-back provision was procedural and remedial, and therefore should be given retroactive application. The DUI statute in Kansas is different from just...
Do we really have to decide whether it was retroactive? Because didn't sentencing occur here after the effective date of the statute?
Sentencing occurred after the effective date of
And
amendment.
J3 says when determining the sentence to be imposed. And if we read that as the time at which the statute applies, then it would be applied at sentencing, and we're not really doing a retroactive application.
That is a point that I intended to make today, which is that if you look at the plain language of that statute, I think what it says is, for the purposes of determining whether a conviction is a first, second, or third. It doesn't say for the purpose of determining whether an offense is a first, second, or third. It contemplates within its own language that we're post-conviction and at the time of sentencing. That's what that look-back provision actually says. And so, yes, to give effect to that language, that's one way to look at it. I guess that I would suggest as well that it's not really retroactive. It actually, by its own language, says after there's been a conviction, to determine whether it's a first, second, third at the time of sentencing, this is what you do. And it does contemplate in and of itself that we're at that juncture of the case. And in this case, that did happen after July 1 when that amendment became effective. And I think what the Court of Appeals said in this case was, well, since this affects sentencing, it has some impact, direct or indirect, therefore it has to be substantive. But the point I was about to make is that the DUI statute is different from just about every other statute, and it is a self-contained habitual criminal statute that contains the definitional aspect of the offense and also the different sentencing parameters, but it also contains this procedural mechanism, which is different from, I think, just about every other criminal statute. And again, that procedural mechanism is something that kicks in after conviction and at the time of sentencing to determine whether it's a first, second, or subsequent DUI conviction that the person is going to be sentenced on. The amendment to this look-back provision that became effective July 1, 2011, didn't change the definition of the crime of DUI at all. It didn't affect the elements of the crime. It also didn't change the respective sentences for DUI, whether it's a first, second, third, etc. Those changed, but this look-back provision didn't have any effect on that at all. It only changed the procedure for determining which sentence should apply, and that, again, I would argue is procedural and remedial. We know from previous case law that prior DUI convictions are not elements of the offense, and they only become relevant really at the time of sentencing in determining a status or classification for the offense being sentenced. So that I would suggest is different from the previous cases that have been considered and that the Court of Appeals took into account in making their decision, because those other cases don't contain this same procedural mechanism.
Do you think that the U.S. Supreme Court case and decision in Dorsey that had to do with the crack cocaine, powder cocaine, has any application here whatsoever?
Well, that was the primary emphasis of my petition for review, because that case came out just, I think, shortly before this Court of Appeals opinion, and I at least suggested that the Court of Appeals hadn't had a chance to consider Dorsey. I think it is a direct analog to this case. Obviously, it's not directly controlling precedent because it concerns federal sentencing statutes, and so in some ways we're comparing apples to oranges. But if you step back and look at the wider view here, it's very analogous to this situation, and I tried to walk through that in the petition for review in just about every respect. But the overarching theme in Dorsey is that modern sentencing statutes should be applied fairly and uniformly, and that ameliorative sentencing changes don't violate ex post facto and should be given application to people that haven't been sentenced and are
Would
still.
you be arguing that if the modern view was that the sentence ought to be enhanced?
Well, no, I wouldn't argue
What's
that.
the
but,
difference?
Well,
I mean, just because it's looked at differently, and it might have a minimal effect or a different effect that weighs in your client's favor, we should take that view. But if it's viewed that based upon science or based upon whatever the policymakers took into account in changing the sentence to make it greater, that shouldn't be a factor?
Well, if there's a statutory change that makes a sentence greater, then I think that does create ex post facto concerns.
Right.
And so
we just don't look at that particular doctrine when we're looking at it. It makes it greater.
don't look at the ex post facto doctrine?
No, I'm sorry, the doctrine that we're talking about that allows you to look back and apply favorably the current view.
I'm sorry, I'm missing the question. I understand your point, which is that I wouldn't be standing here arguing apply the new law to this person if the new law was harsher. And the best answer I can give you, I guess, for that is that I think then you would have ex post facto concerns, and you don't in this particular situation with respect.
Let me change the wording a little bit of the questions just to make sure I'm understanding, because that exchange, as I understood it, referred to a change in the sentence. And as you've pointed out, there wasn't, this look-back provision didn't in and of itself change the permissible sentence. What it looked at was the underlying convictions that could go into that. So let's put that, just take Justice Rosen's questions in terms of if there was a change in the law that added the court to look at convictions that before would have lapsed under a prior law. Would you still be saying that was ex post facto?
Well, that's what happened in July of 2001. They went from a 5-year look back to a lifetime look back. And I think that issue came up before.
Well, do you have a case? I tried to find a case back then as to whether there was a conviction, then July 1st, then a sentencing, and I couldn't find one where the same issue, which would have been presented, if this had been a sentencing in August of 2001, we'd have the same scenario, but the flip side. And do you have a case that where we found that was permissible to look-back lifetime, even though the offense was committed during the 5-year look-back period?
No, I don't have a case. I don't have a case to that effect. There's a case, and I'm just going off my memory, that talked about whether you could use a diversion that was granted back in, before the law changed, and that in its own terms of the diversion contract said this will decay after 5 years and can no longer be used against you. And the Court of Appeals or the Supreme Court said that actually could be used against a person even after the expiration of those 5 years, despite the contractual terms.
But all those cases, the new offense was committed after the law had
Right.
changed. You didn't have the offense under the old law, which is different.
It is different, yeah.
Because that's what the Court of Appeals hung their hat on, and that's what we normally say is the law in effect when you commit the crime is what applies to you. And recently, I think in Williams, where we were talking about foreign judgments, we reiterated it's the law in effect when you do the crime.
And I understand, the court's previous holdings, and that most of the precedent regarding this issue is against my position, essentially. But those, in Williams, you're talking about, as I recall, whether priors from another state should be classified as person or non-person, and it comes up under the sentencing guidelines, which don't have any application in the DUI world. So it really is a different situation. And the previous cases that say you use the law in effect at the time of the offense because that's easy and that's logical and it's efficient, I understand, but that doesn't necessarily mean that it creates uniform or proportional sentences, which is something that the Dorsey case from the United States Supreme Court says that modern sentencing statutes should be attempting to create. And I've set out in, I think, the petition for review. I mean, we have a situation here where somebody could be arrested on June 30th, 2011, and somebody else arrested July 1, 2011, have the same criminal history, be sentenced by the same judge a month later, and one's a misdemeanor, one's a felony, and get widely disparate sentences. And that is exactly what the Kansas DUI Commission, or that kind of situation, I think was trying to avoid. So I see my time is up, but I'd be happy to take any other questions.
The answer to my question was, would you have taken this, use the 2001 amendments? Would you be taking the position, the same position, theoretically, under that scenario?
No, because that would increase the penalties. And so to apply a new law to somebody whose offense occurred before the new law and increase the penalties is an ex post facto problem. To apply a new law to a prior offense that decreases the person's penalties, I think the case law says doesn't implicate ex post facto. It doesn't work to disadvantage the defendant.
So the only way what I was getting at, the whole ameliorative sentencing kind of concept comes into play for your client is only if it lessens the sentence. If it's the modern day view that an enhancement's appropriate to recognize this crime has a certain impact that ought to be warrants greater public safety or whatever the reason might be, that doesn't apply because it's ex post facto.
That would be my position.
So you kind of want it one way and not the other.
I'm not sure that the government has any ex post facto right.
I understand that. No, I understand. We're talking
individual.
about from your client's point of view.
But isn't a real simple answer to all this that the elements of ex post facto, the first look is, does the law disadvantage? And if the law doesn't disadvantage, then we don't go any further.
Right. I think that that even the cases that are cited by the state in their supplemental brief, where they address ex post facto, it walks through the 3 or 4 considerations that you have to make. But one of them is, does it disadvantage the defendant? If it doesn't, then you no longer have an ex post facto problem.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, the appellee state of Kansas appears by Stephen Obermeyer.
Good morning, counsel.
Good morning.
Could you answer my colleague Justice Johnson's first question?
Yes,
Thank you.
and that was about the language in the statute about for purposes of determining. I have the 2011 session laws and was looking at section J, to which Justice Johnson was referring, and that language for the purpose of determining whether a conviction is a first, second, or third in sentencing under this section was not amended. That was the prior version of the DUI statute. So I guess the argument is that this statute's always been retroactive. You always can do that.
I think his point was that you don't need retroactivity analysis to apply the new version to this defendant. I think that was his point.
Well,
Because his sentencing fell after the effective date as currently worded, or as worded at that time.
I guess I would say that I've been here several times arguing that a statute applied, what a statute intended. And I would mention State versus Jabin, where I argued it was prospective, and State versus Horn, where I argued
But this is different. As opposing counsel said, DUI is different. We have said DUI, you do not determine the severity level of the offense until after the conviction. Do you agree with that?
you don't have to prove it you have to prove it at the preliminary hearing to get a bind over. The jury doesn't hear about it. But it is the penalty in effect at the time you commit the crime I don't think you can change that. And I think it's a two-way street.
So at what point in these proceedings did the determination of the sentence to be imposed occur?
In 2009, July 3rd of 2009, when Christian Reese was driving drunk, is when we look at what the penalty was.
And who made the determination of the sentence to be imposed, which is the statutory language? Who made that determination in July 3rd, 2009?
The legislature. It's by setting out that if this is your third or subsequent conviction, that is what the penalty is. And the Court of Appeals in Reese said there's no language in the statute that this is to apply retroactively, because the legislature did not clearly indicate that it intended the amendment to operate retroactively. It operates prospectively unless it's procedural or remedial. And even the district court said, as much as I would like to say that this applies retroactively, it doesn't, because the criminal law in effect at the time of the crime and the penalties at the time of the crime are what applies. And this business about Dorsey and the crack cocaine versus powder cocaine, are we going to say, okay, if you're drunk by drinking Natural Light and over 0.08, that's different than if you're drinking fine whiskey? I don't see the distinction. And to say that the change in this entire statute is not substantive, I think it's not nonsensical, because part of 8-1567 says if your BAC is over 0.08 after 3 hours instead of after 2 hours, that's now a crime.
And so if there's any provision in the 8-1567, the current version, if there's any provision in there that would be ex post facto, then all of it's ex post facto. I mean, why can't we, if I agree with you, the 3-hour change would be ex post facto because it would disadvantage. Does that mean that everything then has to fall under the same ex post facto consideration?
I think you have to look at the entire statute and not parse out different sections. The fine is more also, the $250 fine is different, the BAC is different. So I think you look at the entire criminal statute in effect at the time and not parse out, or at least try and determine, did the legislature intend to parse this out and make it retroactive? And what I was trying to say before, this court has said no matter what the legislature intended, if they didn't put it in the statute, it didn't happen. And
question-
there's no language in there about retroactivity. Where
The
in
question,
other
though,
par-
is do they need it when there are the words in sentencing in the provision? I mean, isn't your argument in its essence reading out those two words, in J?
It also says in sentencing under this section, which references subsection A, which sets out the criminal, what makes it a crime. It doesn't say under any other version of the DUI statute. She wasn't convicted under the 2011, or Christian Reese wasn't convicted under the 2011 version of the statute. It was a 2009 version.
But what does it really say? For the purpose of determining whether a conviction is a first, second, etc. So that presupposes you already have a conviction. You're not determining that on July of 2009 when the arrest is made. You're determining whether a conviction that's already occurred. And then you go down to subsection 3, and it talks about when determining the sentence to be imposed, which we have said happens at sentencing, not during the trial. And so to get to where you are in the Court of Appeals was, we're going to have to ignore some fairly plain language, aren't we?
I don't think you're ignoring anything, because subsection J says, for purposes of determining whether a conviction is a first or more in sentencing under this section, and we're talking about KSA 81567, and I don't think you can parse out that, oh, part of this is retroactively applied, but the elements part is prospectively applied when it's a criminal statute that has criminal penalties and changes the elements of the offense. And so I do think it's different. And we were kind of here in Chamberlain years before when the statute was amended to make it where it used to be a 5-year look back, and then it went to lifetime, and we argued whether or not you could change the statute and whether those convictions that had lapsed would apply.
Did that case, or do we have any case where there was a sentencing occurred after July 1 of 2001, but the offense was committed during the 5-year look-back period?
I don't know if we have it.
You understand what
Yes,
the difference? I know we have a lot of cases that say you committed the offense after July 1. Doesn't matter what you thought about your priors. That was okay to consider them because you committed the new offense after the new law came into effect.
Right.
But I don't know that we had any cases that dealt with sentencing with a lifetime look back when you committed it during the 5-year look back period. Do you?
I don't know if we've had any DUI cases on that issue. I think we just have the cases cited in the Court of Appeals opinion, State versus Edwards, where the penalty for driving while suspended changed while the case was pending, and Edwards got sentenced when it was a misdemeanor, but committed the crime when it was a felony, and was sentenced as a felony correctly. Rice versus State, State versus Hutchinson, State versus Mayberry, cited in the blue brief, are all cases where the law changed, and the court has consistently said, we look at the criminal penalty in effect at the time the crime occurred. And the court even said that in Williams, and said that's simple, it's easy to calculate. Reese wasn't asking for a misdemeanor jury on this case because it's now thinks it's a misdemeanor. She got a 12-person jury, So I don't think we should gerrymander the sentencing date to determine what your penalty should be, unless the legislature says that this applies prospectively. And in other parts of that bill, which was in the session laws, Chapter 105 of the session laws, there were other sections where the legislature did say this applies retroactively. It could have used that language.
Well, but
in
that
815.
was on 1014 where a person was already suspended. We don't have a person already sentenced here. And I mean, that truly was retroactive scenario because the suspension already happened. It didn't say for suspicion hearings that occur after this, you know. So there's a distinction there on the 8-10-14 retroactive language. It had to do that.
Well, I guess my point is, Justice Johnson, the legislature knows how to use that language and,
Well, it
and
knows
could have
how to
put that
use
in.
that language, but if it intended for the new law to apply to sentencings that occurred after the effective date of the new law, then it didn't have to say retroactive, did it?
I think when you're talking about a criminal statute, to change the elements and penalty of a criminal statute, you have to say that it applies retroactively. And subsection J says in sentencing under this section, which is the amended statute, the entire amended statute, which did not go into effect until 2 years after Reese was driving while under the influence of alcohol. And I pointed out an example under the amended version of the statute where maybe I'm not over .08 within 2 hours after driving because of the absorption elimination issue, but I could be over .08 within 3 hours. And I know this court would say that that's ex post facto. So how can we say one part of the statute is, ex post facto? You can't go adding the elements to the crime or making something a crime that wasn't criminal previously, but we can change the penalty. Just to wrap up, I think the Court of Appeals got it right, and every panel of the Court of Appeals that has considered this opinion since Reese came down, which has agreed with Reese, got it right. And having the penalty parameters for an offense fixed as of the date of the commission of the offense is fair, logical, and easy to apply. And for that reason, I would ask you to affirm the
How
Court of
does
Appeals.
fair, reasonable, and easy to apply dovetail with the rule of lenity?
Well, the rule of lenity is you have two statutes in effect at the same time that apply, and so we go with the statute, the penalty provision that has the lesser provision. Here, there is not a conflict between two statutes. We have the previous version of 8-1567, which was repealed on July 1 of 2011, and we have the new version of 8-1567, which went into effect on July 1, 2011. So I think rule of lenity is different because we don't have two statutes that impose a penalty for the same offense at the same time, where you have to look at what the legislative intent was in deciding which statute applies.
You think the rule of lenity only applies if we have competing statutes rather than an ambiguity within one statute? Seems to me that we've applied it where there's an ambiguity in a penal statute and said that we have to construe it in favor of the person against whom it's being applied, so long as it is a reasonable interpretation.
Even if it was within the same statute, I guess I'm not seeing where the conflict is, where you have two possible penalties that could be imposed, where you have to ferret out what the legislative intent was. We've always had the law that since Kansas became a state yesterday, that the law in effect at the time of the crime is what controls. 8/15/67.
But can that is our rule, court-made rule. Can the legislature determine when the sentencing is to be determined? I mean, can it decide that it's this provision? Was it permitted to do what I've suggested that it did, is saying that the statute was to apply when the sentence is determined, or what sentence to impose is determined? Was it permitted to do that, the legislature?
If the legislature didn't change the elements of the crime and made the penalties less and said it's our intent to do this, I would suspect that the legislature could do that. But that's not this case, is our argument in this case.
Any further presentation, counsel?
No, thank you.
Any more questions? Thank you. Reserve 3 minutes for rebuttal.
Thank you. I would suggest that the rule of lenity says if a statute is subject to two different interpretations, for instance, in this case, Mr. Obermeyer's or mine, that the rule of lenity means that the court has to apply the one that would be most favorable to the person subject to it. And so I think that is the situation that we have here. I would also say, with respect to the argument that, we went from the old statute where it was 0.08 within 2 hours to the new statute was 0.08 within 3 hours. Well, that's a change to the elements. And we know that that is a substantive change. And when we say, well, the fine went up by $250 on each of these respective convictions, well, that goes to a sentencing or penalty provision, and we know that that is substantive. And that is not the statute that's at issue here, or the provision of the statute that's at issue here.
I think the hurdle that I see that Mr. Obermeyer pointed out to a reading of when determining the sentence to be imposed means at sentencing. The hurdle is that you have a preliminary hearing where we've said that the state has the obligation to prove the priors if it intends to prosecute for the felony.
Well,
And so the point is that you've already determined the severity level at preliminary.
well, what the statute maybe ought to say, but doesn't, is that for the purposes of determining whether an offense is a first, second, or subsequent, in charging under this section, here's how you consider it. That's not what it says. There are situations where a felony is charged, it gets past preliminary hearing, maybe the person waives preliminary hearing, we get to the point of sentencing and get a pre-sentence investigation comes back, and lo and behold, they can't find a prior, or they can't prove a prior, or we get the documents and it shows that it was an uncounseled plea or something like that, and we say that one doesn't count.
Is there a possibility that your client could be convicted of a felony, but only sentenced to a misdemeanor?
He could be convicted of a DUI, and then it has to be determined what severity level or what, whether it's a first, second, third, etc. And I think that that's what, I believe it's the Seams case says essentially, that this is not, Seams is S-E-E-M-S, and it says priors are not elements of the crime and that they don't become relevant until there's a conviction and you're at the point of sentencing and you're determining whether this is a first or second or third. So it's wholly feasible, and I think in fact happens, that people get charged with felonies and may even plead guilty or get convicted of a DUI, but when we get to the sentencing, they file a motion to strike a prior or something like that, and the judge says, yeah, I'm throwing that one out, and therefore you've only got one prior, and it's a misdemeanor.
I don't see how under that argument then that you can say that the 2001 provisions were a violation of the ex post facto law, because you wouldn't have known what the possible sentence would be until after the case had proceeded. Under that scenario, there is no set sentence of any kind in a DUI action until the day of sentencing. There's no, the right doesn't vest.
Well, I think that that's the situation that we're in, and it's one of the problems with these cases. I mean, there are also situations where you plead guilty to a third-time DUI, and lo and behold, it turns out to be a fourth-time DUI. It's one of the problems with the DUI statute. It kind of exists on its own, and gets changed a lot and interpreted a lot, and it's sort of grown its own way, different from all of the other kinds of offenses in Kansas, and it's a real problem that neither party sometimes knows whether this is a second time, third time. You may get a PSI back and it's a sixth time. Obviously, the defendant ought to know whether he's got prior DUI convictions, but they don't always. And so I think it is a situation where it is determined at sentencing what the person's prior criminal history is, what the person's prior DUI history is, and exactly how sentencing should proceed at that point.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.